Good morning, everybody. Sorry, start again. Good morning, everybody. I hope you had a good evening. Thank you all of those who joined last night to the voluntary session. It was a lot of fun, I think. It gives me great pleasure this morning to be moderating this session on the impact of HIV and TB criminalisation. We have two great speakers this morning. I feel a bit like KELIN and I are becoming like the Punch and Judy show here kind of thing. It's like, we have Richard Elliott, the Executive Director of the Canadian AIDS Legal Network, who's come all the way from Canada to be with us. Richard is somebody who has worked in this field for many, many years, and it's a great opportunity for all of us to learn from his experiences. Brian has morphed into KELIN. KELIN you've met, she needs no introduction. She'll be looking at the impact of TB criminalisation. So we're going to start with Richard. So over to Richard. Welcome to South Africa, all the way from Canada.
Thank you, Michaela, for the introduction. Thank you to SALC and ARASA and the other organizers for the for the invitation to be here. I too will end up speaking too much by the end of tomorrow, so let me try to keep the remarks this morning relatively brief. The purpose of this session, as I understand it, is for us to dive a little bit deeper into a consideration of the impacts of, in the case of what I'm going to be speaking about, HIV criminalization, and then KELIN will be speaking about the impact of criminalization and I guess other punitive laws and policies related to TB. So what I wanted to do is, first of all, start by looking at what some of the intended and claimed effects are of using the criminal law to deal with HIV transmission, exposure, or non-disclosure. And then after interrogating those for a little bit, turn to what some of the harms are. And before I jump into specific points in each of those two categories, I think it's worth noting, first of all, that we do have a growing body of evidence about the impact of HIV criminalization. But I don't think we can say that we have as robust a body of evidence for every single dimension or aspect of HIV criminalization as we might like. If we believe that our laws and our policies ought to be based on and informed by evidence, which is generally a good approach to take, then it's unfortunate that we are still, in many respects, making law and policy more based on perception and desire rather than actual evidence. That said, we do have some evidence that should inform our thinking, and that is important for us to consider as we make arguments about the appropriate scope and the inappropriate overextension of the criminal law in this domain. So, let me start by talking about what some of the intended and or claimed effects are of criminalization of HIV. And here, if we start from first principles, as we're often trained to do as lawyers, let's just think for a moment about what purposes the use of the criminal law in general is said to serve, and then question the extent to which those purposes, those objectives, can be said to be achieved when applying the criminal law to HIV. There are different ways of categorizing and describing the ostensible functions of the criminal law. I don't think that in substance they vary that much, although people may use some slightly different categories. I'm using a typology of 4 functions or objectives of the criminal law here, which I hope, will adequately cover the waterfront. So there are 4, in my view, main functions of the criminal law. You see them listed here on the left-hand side, and I'll go into each one of them in a little bit of detail in a moment. The thing I just want to note at the outset, though, is that 3 out of those 4 objectives ostensibly bear some relation to the public health objective of HIV prevention. And it is often the case that when arguments are made that the criminal law ought to be used to deal with HIV non-disclosure, exposure, or transmission, that this is a public health intervention, that the criminal law will serve as HIV prevention policy. And so we should consider then the ways in which the use of the criminal law might in fact relate to a public health objective, and the ways in which the criminal law doesn't. And I would suggest that the first three functions of the criminal law that are listed here, that is incapacitation, rehabilitation, and deterrence, arguably, at least in theory, could serve some sort of public health objective when it comes to preventing HIV transmission. The fourth objective, which I will suggest is actually probably the one that animates resort to the criminal law more than any other, actually bears no relationship whatsoever to achieving a public health objective of HIV prevention. So why do I say that? Let's turn to each of these. The first objective of imposing criminal sanctions on someone that we might think about is the claim that this will incapacitate the person who is the subject of the prosecution and the punishment, thereby preventing them from causing further harm to someone. The idea being that if we restrict the person's liberty in this circumstance, which could include incarceration in some sort of penitentiary, but could involve other kinds of restrictions on liberty, then this will prevent HIV transmission, at least during the period during which the person is subject to this criminal penalty. Now, if we look at that claim a little bit more carefully, I think we note some rather important caveats to the claimed effect of using the criminal law for this purpose. First of all, it's a time-limited benefit if in fact the person is separated from other people, because it would only obviously apply during the time under which they are in fact subject to that restriction. Of course, what we also know is that putting people living with HIV in prison is actually to put people in an environment where the risk, and here I'm just talking about the risk of further transmission, although there are many other risks that are of concern to us as well, of course, is higher. We know that prisons are environments in many places where access to evidence-based HIV prevention tools and measures are simply not available or not easily available to people. So it doesn't necessarily serve an HIV prevention function to put people living with HIV in such an environment where you then deprive them of access to adequate HIV prevention tools. And there may be other factors at play, including sexual violence in prisons that of course contribute to HIV transmission risk. And then finally, just as a broader consideration when it comes to putting people living with HIV in prison, we mustn't forget that the health of people in prison is actually the health of the community at large, because in fact, most people who spend time in prison will eventually leave prison. And so what happens to people in prison, including what happens to their health, has downstream implications for community health more broadly. So perhaps there could be an argument that by incapacitating people through incarceration, you might achieve some sort of HIV prevention function, but I would suggest that that proposition is actually not nearly as strong as it sometimes appears at first glance, and is quite heavily caveated. So what about the second objective that we might try to achieve with using the criminal law in this area? That is to rehabilitate someone. And that word should probably be in quotes because I think it's often used in rather suspect ways. The theory here is that by imposing a criminal penalty on someone for some behavior that society has deemed is problematic, that this will eventually produce some sort of change internally in that person's consciousness. That is, they will recognize and accept that the behavior in which they have engaged, for which they are now being punished by the state, was wrong, was not something that should have been done, and is not something that should be done in future. Now, this is often said to be one of the major purposes of the criminal law, but I think, as most criminologists and sociologists will probably suggest, the evidence that the criminal law serves a particularly rehabilitative function is mixed at best, and that's putting it charitably. And it also raises some important questions about which conduct is going to be seen by society, by the majority, as something that is blameworthy and deserving of, quotes, rehabilitation, because it reflects some sort of lack of control or some sort of moral defect. And I think we need to be careful here when we start making appeals to the coercive power of the state to serve an ostensibly rehabilitative function, given what we've seen in history about how this power of the state to, quote, rehabilitate people has been used and applied to conduct that I would suggest doesn't, in fact, carry the degree of moral blameworthiness that it requires some sort of rehabilitation. I think it's also worth questioning the effect, the rehabilitative effect of the criminal law when it runs up against, when the prohibition and the penalty runs up against what may be other well-established and widely accepted community norms. So for example, if you're a sexually active gay man in 2018, you may well have the experience of living in a community in which there are certain norms that are established around expectations of disclosure or not in various kinds of sexual encounters. And I just give gay men as an example, but it's not necessarily the only example. If, in fact, you have sexual encounters with partners where there isn't necessarily an expectation of disclosure and there's a sense of shared responsibility for protecting against the possibility of HIV transmission, but the law then steps in and says it was a crime for you not to disclose in X circumstance, we have to question whether the dominant criminal law norm that is being articulated there, running up against what is actually an established community norm, is likely going to serve some particularly rehabilitative function. Am I likely to think, yes, you are right, I was wrong. That was, I should not have had sex with that person without disclosure, even though we practice safer sex, even though we were both aware of the risks of HIV or other STIs. And because you are criminally punishing me, I recognize now that I'm a bad person and I must never do that again. I don't think there's going to be a strong rehabilitative effect in such a circumstance. And we don't really have much evidence, actually, to back up this claim that the criminal law will serve this rehabilitative function. So again, I would suggest the intended effect here is not evidence-based and raises some serious questions. So then what about the third claimed effect of HIV criminalization? The notion that the threat of criminal penalty will deter people from doing the things that are criminally prohibited. Now, this is perhaps more than the incapacitation argument or the rehabilitation argument. This is actually one of the more common and potentially stronger arguments for using the criminal law. The theory being that someone will engage in a rational cost-benefit assessment and say, well, there's a risk of prosecution if I do X, therefore I'm going to modify my behavior in this particular way so as to avoid that potential penalty. There is, however, little evidence to suggest that the criminal law has much of a deterrent effect in the circumstance of HIV criminalization. Now, that's not a reason not to have laws about things. We don't say, well, we won't have a law about shoplifting because people will still shoplift. Just because people break the law sometimes isn't a reason to just chuck the law. But if we are going to think about, at the end of the day, what are the pros and the cons of using criminal law to deal with HIV non-disclosure, transmission, or exposure, we ought to at least have some concern for the extent to which the supposed deterrent effect of the criminal law is in fact borne out in practice. We have to weigh that in the balance. And there really just isn't any evidence to suggest that it has much of a deterrent effect, if any. Now, part of the reason for that is, of course, that first of all, it requires that someone know that they have HIV, because if you don't know that you have HIV, then it's not likely you're going to be too concerned about the potential for being criminally prosecuted for transmitting or exposing a partner or not disclosing that fact. So already we have limited the potential benefit of the criminal law there. And very importantly, as we'll come to in a moment, we've introduced already a downside to the use of the criminal law in the sense that we are then creating an incentive for people to avoid knowing their HIV status, because that then provides some sort of ability to avoid potential prosecution. The potential deterrent effect of the law also requires that people have a correct understanding of what the law actually prohibits. And when the law is vague or overly broad, then of course that creates additional challenges for the law having a particularly significant deterrent effect. And finally, as in this area, as in any other, the extent to which the criminal law is going to have a deterrent effect on people's behavior will depend very heavily on the extent to which people perceive that there is a risk of actually being prosecuted and convicted. What about the fourth claimed benefit? And this is the final function of the criminal law that is articulated, and that is the retributive function of the criminal law. And so this is the one that has nothing to do with actually achieving some sort of HIV prevention benefits. The other three did. The notion being that you would incapacitate people, you would rehabilitate them and produce a change in their consciousness, or just the threat of punishment would deter them from doing certain activities, thereby achieving HIV prevention as an objective. For retribution, we're not concerned about that at all. This is just about imposing a penalty under the criminal law on someone because their conduct is deemed sufficiently morally blameworthy that it deserves punishment. Punishment for the sake of punishment, because that is thought to be justice. So first of all, there is no HIV or other STI prevention benefit here or objective that's being served by the criminal law. And to the extent that we want our public policy in the area of HIV to serve that purpose, then we ought to discount, I would suggest, this argument for the use of the criminal law. Now, this isn't to say that we can discount it entirely. There are long philosophical debates about the proper role of the criminal law in imposing retribution on behalf of society for morally blameworthy conduct. We don't need to get into those now. But I would suggest that at least if we're going to appeal to punishment for the sake of punishment as our intended impact of the criminal law, then at most this offers a very limited justification for applying the criminal law, that is, applying it in very limited circumstances. To those where, in fact, you can say the conduct is so morally blameworthy as to deserve punishment. And so at least a few of those criteria, I think, that ought to be in play, and which are not in many criminal laws or the application of criminal law in many jurisdictions, is that, of course, the person has to know that they have HIV. Otherwise, there would be no possibility of suggesting that they deserve punishment. Secondly, they have to have the requisite degree of mental culpability, or mens rea, as was referred to yesterday. So where in the degrees of mental culpability between negligence on the one hand at the low end of the scale and actually intending to cause harm to someone else, do we draw the line about where the criminal law will be triggered and applied? And then finally, we have to consider the circumstances that might mitigate the moral culpability of someone. Why did the person not disclose to a sexual partner? Was it that the circumstances of the encounter were such that that wasn't an expectation generally operating in the circumstances of that encounter? Was it that there was a concern about violence or other sort of serious negative consequence? How difficult have we made it for people to disclose HIV, to claim that stigmatized identity? Those are all things that in my submission ought to weigh into the balance in terms of where we might legitimately apply the criminal law, if our purpose is to punish for the sake of punishing what we consider to be bad behavior. So there are some potential impacts of the criminal law as criminal law following standard criminal law theory. I would suggest the arguments from those functions of the criminal law justify at most a relatively limited application of the criminal law. Then the other thing we have to weigh on the other side of the balance, of course, are the harmful effects of HIV criminalization. Because even if we thought, based on those four objectives of the criminal law, that there was some potential limited justifiable use of the criminal law to deal with HIV criminalization, we don't necessarily want to cut off our noses to spite our face. If in fact we're going to do more harm than good with using the criminal law, then that should be a pretty good argument for being rather restrained in its application. And so there are numerous harms to criminalization, and for some of these we have fairly substantial evidence by this point. For others, the evidence is a little less well documented, but I think nonetheless reasonable to propose that these harms exist. So I have about 12 or 13 of them, and I won't talk about all of them as long as I talked about each of the 4 functions of the criminal law, but let me just go through them briefly to give you some sense of what they might be. And many of them, I think, will be relatively intuitive to most people. The first, of course, is that by suggesting that not disclosing you have HIV to a sexual partner, that will attract criminal consequences, we are encouraging other people who know or believe themselves to be HIV negative to enjoy a false sense of security, to make certain assumptions in their sexual lives about their partners and the risk that may or may not be present in their encounter. And we see this time and again in the testimony of complainants in HIV criminalization prosecutions. And I think here of the cases that I'm most familiar with, which are from Canada, which of course has either the 2nd or 3rd largest absolute number of prosecutions in the world. And so we've seen in the evidence at trial over and over complainants saying that they didn't think that there was really anything to worry about. No, they didn't ask any questions. And the assumption that is operative in many such encounters is that, well, I don't need to worry about this possibility. I should not have to think about this. He has to tell me if he has HIV because the law says he must, or at least that's my perception of the law, which is not always, in fact, accurate. Further illustrating the point that has already been made repeatedly yesterday about how the criminal law is a rather blunt instrument to try to deal with what are complex human interactions. And so by using the law in this way, we encourage people who, quite understandably, it's the human condition, don't want to have to think about potentially negative things like HIV in the world and the possibility that it might affect you. We encourage people to think, I don't need to worry about that. There's already a perception out there that HIV only affects certain people, certain kinds of people who do certain kinds of things. And if I'm not one of them, if I'm not one of those gay people, if I don't use drugs, etc., then there's nothing for me to worry about here. And if there were something, he would have to tell me. And so I don't need to take precautions. It's really entirely on him, the onus, or her. The use of the criminal law, particularly when prosecutions are applied over broadly, also spreads misinformation about HIV and about how it's transmitted. And we see this over and over and over again. Because certainly when you see the news story covering the latest prosecution that in some cases will have a misleading or inaccurate headline or sometimes even content in the article, suggesting that a very serious criminal charge is being pursued against someone because they've created some great risk of transmitting HIV. In fact, in many cases, the conduct that is the basis for a criminal charge is conduct that poses statistically a very small per act risk of transmission. As we've heard already yesterday, from any given sexual act, there is not a high risk of transmitting HIV, and yet we have very serious criminal charges being laid against people in many cases for things that did not in fact pose any significant risk of transmission. The public message that is received is that, oh, this must be really serious and risky conduct. Otherwise, why would they be prosecuting someone with such a serious thing? This does not help our HIV prevention efforts because it promotes inaccurate misinformation. Out of misinformation often is born fear and stigma. Because people fear something that they have inaccurate information about, because it is stigmatized in various ways, people find it more difficult to disclose. And if what we're wanting to do in our public policy is encourage disclosure, I'm getting an echo. That sounded rather intelligent though, so keep it. Okay. When we reinforce stigma, it makes it more difficult for people to disclose. And of course, the potential for criminal prosecution generates fear in other ways, including on the part of people living with HIV. The fear of being accused or prosecuted. It is weaponized in many cases, as we have seen, as another form of abuse against someone in a relationship. The threat of actually alleging that someone has not disclosed to them as a means of exercising control over people. And it's both the prosecutions themselves and the amplifying effect of media coverage, particularly if that media coverage is not well informed and is stigmatizing in and of itself, that contributes to that stigma. As I've mentioned already, the risk of possible criminal prosecution creates an additional disincentive getting tested for HIV and potentially other sexually transmitted infections. And I note the other sexually transmitted infections here because there's actually an interplay between these. So if, for example, I go for STI testing in Toronto, where I live, I am asked, and I don't think I should be, questions about how many partners have you had, what kind of sex do you have. I don't get asked about whether I disclosed or not, or at least that's not been my experience so far. But if you're a person living with HIV and you get diagnosed subsequently with another sexually transmitted infection, it's almost certain that that's going to send up a red flag, at least in the minds of the testing provider and potentially public health to whom the test results are reported, that perhaps there was some risk behavior here. And we certainly are aware of cases in which someone who's HIV positive, who has acquired another STI at some point, has come under that additional degree, an additional degree of surveillance. And right there, we have a disincentive for people to seek testing for other STIs, which is why, although I'm a minority voice on this, I'm actually a strong proponent of having anonymous STI testing as well as anonymous HIV testing. That aside, we are creating a disincentive for people to get tested for HIV, and of course, since testing is the gateway to treatment, we're also having a deleterious effect on access to treatment for people with HIV. Now, this is one of those areas where we have maybe less evidence of this harmful consequence of HIV criminalization than we would like, partly because it's a difficult thing to study, partly because people's decisions about getting tested for HIV are bound up with a whole bunch of other considerations beyond just criminal law. But I don't think we can discount that it is a consideration. Certainly for me as a sexually active gay man, it is something that I think about when I think about getting tested for HIV or STIs. What would be the consequences of knowing that information? And I know very well, from where I come from, given the work I do, what some of the consequences might be, and that it's not a particularly appealing prospect. We do have a bit of data, and it's one of the relatively few pieces of data that actually comes from a study done in Ottawa in Canada among gay men, finding that a significant minority of them, in fact, were concerned about HIV criminalization and that was a factor creating a disincentive to seek testing. There haven't been many such studies replicated, but there is some data from a public opinion survey of people living with HIV in the United States as well a number of years ago, in which a substantial proportion of people with HIV felt it was reasonable, given the prospect of HIV criminalization, to avoid seeking testing. So we do have some evidence, contrary to what some might suggest, that there is really no concern here. Finally, or not finally, I'm only halfway through this list, I'm sorry. The potential for criminal prosecution hinders access to post-exposure prophylaxis, for example, in the circumstance in which a condom fails. So if I have not disclosed to a sexual partner, but we've used condoms following good standard public health advice from the beginning of the epidemic, but then something happens with the condom and it breaks. It happens occasionally. I would suggest our concern about condom failure, and at least the concern of prosecutors and courts about condom failure in this area is overstated. But it does happen occasionally, and if it does, ideally that person might wish to consider seeking post-exposure prophylaxis where it is available. But then I'm in a situation of considering, well, do I now disclose to you because I didn't disclose before? If I disclose now, even though I acted responsibly and used a condom, are you going to be upset? Quite possibly. Is that upset going to turn into a call to the police and eventual criminal charges against me? So that's not a particularly good public health outcome. Beyond impacts specifically on health, we should think about other human rights that are implicated in a harmful way by the overuse of the criminal law. There is widespread invasion of people's privacy when we deploy the criminal law in this domain, particularly medical records. So in many, many jurisdictions, I think probably most, the notes that are made by a care provider, a doctor, a nurse, a counselor at an AIDS service organization are subject to subpoena. And the contents of those notes and of any conversations that are had with someone could be presented by the prosecution as evidence in an HIV criminalization charge. And in fact, that happens pretty regularly where I come from, and that's not unique. There is no absolute privilege that protects the confidentiality of those communications, of that information, unlike, say, the communications between a lawyer and a client. Now, that may vary from jurisdiction to jurisdiction. Some jurisdictions may, in fact, have stronger protections for the confidentiality and prevent that information from being adduced in evidence. But that is by no means universal, and I don't know that it's actually the majority of jurisdictions. So right there, you've undermined the therapeutic relationship between the patient or client and the provider, because anything that you share with them can be and has been used as evidence against you. So we would often say to people, don't share information with your doctor. Don't share information with the nurse. Don't share information with public health any more than you absolutely need to. And we, in fact, have evidence showing that people are concerned about sharing contact information of past sexual partners, for example, because you have then just handed over information that can be used by the state against you. That, again, undermines public health practice. In some circumstances, depending on the law of the jurisdiction, there are also invasions of one's bodily integrity. In those jurisdictions where forced testing for HIV or other transmissible infections is permitted by law, in some circumstances, we need to weigh that in the balance as a harm of HIV criminalization as well. Although I would suggest that probably as a matter of constitutional principle in most jurisdictions where there is a robust body of law in this area, when the state actually forces you to provide certain information that can be used against you, then that would violate a right against self-incrimination, and so might well be kept out of evidence. We have certainly seen unjust and disproportionate sentencing when it comes to HIV criminalization. Now, I'm not aware of any comprehensive survey across all the jurisdictions or most of the jurisdictions where HIV criminalization has been documented about how the sentencing in those cases compares to other comparable sorts of offenses. But certainly in our context, where the use of aggravated sexual assault charges has been the most common, when you compare the sentences that have been imposed against people accused of sexual assault based on not disclosing HIV status to sentences in other sexual assault cases where the assault has involved things like force or fear, which is what we normally think of when we think of a sexual assault, there is a disproportionate higher sentence in the HIV non-disclosure sexual assault prosecutions. And in a number of jurisdictions, including mine, once you're convicted of a serious offense like that, it is mandatory that you be designated as a sex offender. So that's an additional harm on sentencing. In many jurisdictions, people who are not citizens of that country who are convicted of serious criminal offenses can also be subject to deportation from that jurisdiction, and that has happened in a significant number of cases. So that's another downstream harm of overly broad HIV criminalization. There are numerous harmful consequences of putting people in prison, of course, especially given prison conditions in many parts of the world. It is damaging to people's health, particularly if they might already be immunocompromised, and of course many other human rights violations that people are subject to in prison. We see in some jurisdictions at least, based on the evidence we have, selective prosecutions, often discriminatory, sometimes by intent, but certainly by effect. And of course, who gets targeted for the use of the criminal law will vary in context. Who is deemed more marginal and more criminal will vary by context. Certainly in a number of contexts, we have seen a disproportionate application of the criminal law against racialized people, so there's a racist dimension to criminalization in many contexts. Sex workers in many jurisdictions face potentially additionally burdensome use of the criminal law if, for example, sex working while positive is an offense, which it is in some jurisdictions. And in some jurisdictions, sexual minorities have been disproportionately targeted for prosecution. We've heard already yesterday, but it's worth mentioning again, the gendered dimensions of HIV criminalization. And one of those dimensions is the additional burden that HIV criminalization can impose on some women, particularly women who risk some of the worst consequences of systemic gender inequality, including violence or other economic harm, if disclosing their HIV status, and yet are caught between that and the prospect of being criminally prosecuted if they don't. And so they're caught in a double bind there. I have a... There, I just shortened the, well, this is a slightly different version of the presentation. So I already mentioned the harm for women. There is more broadly, of course, for anyone accused of or convicted of an HIV criminalization offense, there is the broader impact of social ostracization, often reinforced particularly through sensational media coverage, and discrimination that can then follow once outed as someone living with HIV and someone not only living with HIV but accused of what is often a very serious criminal offense like sexual assault or something similar, which can and has led to things like the loss of housing, work, and relationships. And then just a very more minor note, but in fact in some circumstances we can also see that research into sexual health is actually also a potential victim of overly broad HIV criminalization because, of course, it means that people are less likely to want to share information with researchers, which at the end of the day doesn't help us generate the data we need to inform public policy. So with apologies and thanks to our colleague Matthew Elliott from the UK, I have shamelessly ripped off this already nicely laid out vicious cycle of HIV criminalization because I didn't want to recreate it myself using graphic stuff late at night. So I just copied his slide from a presentation he gave a number of years ago, but basically I think it illustrates nicely the cycle of HIV criminalization accompanied by poor media coverage that contributes to stigma and fear, which then make disclosure more difficult, so there is more likely to be non-disclosure, which then leads to sex being based on assumptions of there not being a risk, which then in some circumstances will lead to transmission or exposure, which will then lead to criminal charges, and the cycle begins all over again. So we need to break this cycle, and there are a number of points during this cycle where interventions can and should be made. But I think the point is we've got a mess here. It's a nasty mess of harm that arises out of HIV criminalization. In some cases, it's a self-perpetuating cycle of harm. And when we weigh it against the fairly limited benefits or ostensible benefits that are claimed of using HIV criminalization, I would suggest that the harms rather substantially outweigh the good of using the criminal law in this domain, and we must therefore argue for a very limited application of the criminal law. And I will stop there and hand it over to my co-panelist.